Welcome to the Manhattan Institute's eventcast titled Biden's Overture, the State of the Administrative State. I am James R. Copland, Senior Fellow with and Director of Legal Policy for the Manhattan Institute for Policy Research. And today I'm joined by my friend and colleague, Manhattan Institute visiting scholar Richard Epstein, who in his day job is the Lawrence A. Tisch Professor of Law at the NYU School of Law, where he's also the director of the Classical Liberal Institute, and he's also the Peter and Kirsten Bedford Fellow at the Hoover Institution. So, Richard, thanks so much for joining me here today. Both of us wrote books that were published last year. Yours was pre-published by the Manhattan Institute in fall of 2019, and then published by Rowman and Littlefield last spring, and then mine came out in September of last year, both involving this subject, regulation and the administrative state. My book was entitled The Unelected, How an Unaccountable Elite is Governing America. And Richard's is entitled The Dubious Morality of Administrative Law. And each of these books offers a detailed account of the evolution and current state of the American regulatory apparatus and the problems with it. Together, Richard and I in our books both argue that the administrative state is at odds with other principles that we hold dear. Professor Epstein focuses on how the administrative state undermines the rule of law itself, and I explore principally how the administrative state conflicts with norms of popular representation and accountability. So now we've had a change of presidential administration, a 50-50 Senate, shifts in the composition of the U.S. Supreme Court, and we thought it would be a good time to revisit anew these issues we explored in our books. They're as salient as ever. In just its first week, the Biden administration issued an unprecedented flurry of executive orders shifting government policy on a host of issues, ranging from pipeline permits and wetlands regulation to rules governing college sexual assaults and gender identity, a host of other things. So, Richard, first of all, welcome. And we've got a lot of ground to cover in only an hour. We each, of course, wrote books on this subject. So we'll get started. I want to let the audience know that they can, in our sort of Slido on the side, submit questions that will get in front of Richard and myself. We may not get to them until after we've talked for a while on these issues, but please submit them. So Richard, tell us a little bit first, your book, the impetus for it, and why you think the administrative state itself, as it exists today in the United States, is one of dubious morality.
Well, the book was basically written in part as a response to an article that was published by Cass Sunstein and Adrian Vermeule. I think it was in 2018 in the Harvard Law Review, talking about the immorality of administrative law. And the foil they took was a man named Lon Fuller, who had written a very famous book on this particular subject some years before, called The Morality of Law. And Fuller, turns out, was a deep traditionalist. What happens is he says that the key features associated with a decent administrative state, not an administrative, a decent government. He did not talk about administration mainly. He talked about legislation and rule. And he had a king named Rex. And what Rex did was he managed to bumble his way through by violating all sorts of fundamental norms, inconsistency, complexity, retroactivity, and so forth. And Fuller, in effect, was somebody who basically believed that the traditional values of the rule of law, dating back to John Locke, would be appropriate. The Sunstein and Vermeule approach was to take what they perceived to be the Fuller position with respect to legislation and apply it to administrative law. And I read it and I said, there's a real deep disconnect in this particular case. If I start looking at administrative law, what I do is I distinguish between two periods. The first of the periods would be the, roughly speaking, pre-1937 period, where I thought administrative law did work in a sensible fashion. I'm not one who, for example, like Philip Hamburger, believes that you can do without an administrative state. There are too many things like running a motor vehicle bureau, collecting taxes of one kind or another, even tariffs, are going to require it. But when you started to look at the earlier principles, it seems as though they were very well constrained. Then after you get to the progressive era, what happens is the mandate of government increases in two major dimensions. The first of these dimensions is federalism, and all of the traditional restraints associated with the Commerce Clause and the taxing powers are no longer there. So that, with the exception of occasional islands, in terms of general economic regulation and taxation, the federal government has a full power. Greater power means greater discretion, more things you can do, more things you could bundle together, more things that you can trade off. At the same time, economic liberties and property rights took a rather detailed drubbing at the hands of the Supreme Court. So now the individual rights did not protect you of one thing or another. So what happens is when you create this vast amount of power, legislatures cannot do it by themselves. They have to start to fill it in. And so what you see in the New Deal period is a flurry of statutes, most of which have very broad delegations. The most famous of these was probably the massive delegations under the National Industrial Relations Act, which was invalidated in Schechter, which allowed the administrators, for example, to basically say, well, the minimum wage in the United States will be X without any legislation. The more serious kind of situation was very much evident in a case called the NBC case against the Federal Communications Commission or the United States, in which how do you allocate frequency? There's a different problem. By public interest, convenience, and necessity, a formula to be made later. And this kind of leads into what you say, so I'll stop here, is what Felix Frankfurter said is, well, everybody knows that you can't possibly think that the government's main function is to determine the rules of the road. We have to go further and allow it to determine the composition of the traffic. That was something which, in fact, had been done through the Motor Vehicle Act, and it's a disaster. Because what it does is it allows you to say that you can send beets on a truck going to California, but you can't use anything going back. You have to have it empty. So all these permitting restrictions and so forth. He thought it was just fine, but did he set out what the rules were? No, he said, I'm going to delegate it to the FCC. They spent 18, 19 years coming up with a set of rules that are so flaccid that anything is consistent or inconsistent with them. So if you have rules of that level of generality, nothing turns out to be illegal except sensible market behavior. And that then gets you back to your theme. We have very large delegation from Congress. And then the question is, how is it that these unelected commissioners decide to exercise their power? And you may take it from here.
Exactly, Richard. And I want to emphasize here, I'm focusing on these accountability mechanisms. You're focusing on these sort of theoretical rule of law principles, but we're both sort of interlaying this with the legal history and the evolution here in our two books. And sort of the implicit undercurrent here is also something that Richard and I broadly agree on, the sort of limited government principles. And in your book, you sketch out fairly early on how these limited government principles are in some ways inherent to the old rule of law principles that undergirded the old administrative state. And I concede upfront in my book that to some degree, the reason we've had these broad delegations is the growth of government itself. And just to put that in perspective, I put this in chapter 14 of my book as I'm sort of summarizing everything up. The scope of the federal government in the first Congress, the federal budget was $639,000. Now, of course, there's been inflation since then, but if we scale that up with ordinary inflation metrics, that's about a $10 million federal budget. Well, the last budget before the COVID pandemic, when we've just sort of opened the spigots in the last 12, 13 months. But even before that, in 2019, the last federal budget was $4.4 trillion, only about 77% of which we paid for through tax collection. So 4.4 trillion from 10 million. I mean, you could see the enormous orders of magnitude growth of the federal government. And we've seen the same thing, somewhat by necessity, perhaps, when you're growing that much. But we've seen the same thing in administrative rulemaking. And to give folks a picture of the scope of this administrative rulemaking that we've seen, at the time I wrote my book, we'd already passed 200,000 rules since we started chronicling them by statutory order in 1976 in the Federal Register. The first year of the Trump administration, they added 61,000 pages to the Federal Register, which sounds like a lot, except the last year of the Obama administration was 95,000 pages added to the Federal Register. And in fact, the first year of the Trump administration added fewer pages to the Federal Register than any year in any administration dating back to 1993, the first year of the Bill Clinton administration. So, the scope of this is just massive. And but they're really sort of a little bit severable pieces of this. And in the first section of my book, as I engage with the rulemaking apparatus itself. And I think it's important to distinguish between what I call the rulemakers and then the enforcers, because sometimes we have implicit rulemaking going on at the federal government level without real rulemaking itself. And we'll get to that in a minute. And some of it's implicit in some of these Biden administration early executive orders, which are sort of new iterations on the old guidance letter strategy that the Obama administration engaged in the latter part of its 8-year term. But I categorize these as pretty simply legislating without Congress, administering without the executive, and judging without the judiciary. And we see all three of these things coming into play, which is why we get these sort of unaccountable administrative agencies really writing the rules. And it's important to understand, and the constitutional framers set in place not only liberty protections, which include, of course, the structural constitutional protections, as Brett Kavanaugh emphasized in his confirmation hearing. I mean, the structural constitution is designed to protect our individual liberty by dividing power among the branches of government horizontally, and then dividing power vertically between the federal and state governments, but also designed a fairly, they wanted a government that was able to be active. I mean, this was part of the project of moving to the Constitution from the Articles of Confederation, but they wanted it to be accountable. And it wasn't just accountable, oh, you win one election by a small margin and you can totally remake society. No, you needed to win a series of elections in the Senate, implicitly a majority of the states, as well as a popular election in the House. And if you didn't have the president going along, you needed super majorities. And this sort of bicameralism and presentment makes it hard to make radical changes in our law. It is a relatively conservative principle, but it's designed to move us a bit more through a consensus process and develop clear accountability on lawmaking, on our lawmakers. But what we've got now is this delegation. You mentioned the Schechter Poultry case from the 1930s, where vast discretion is given at the stroke of a pen from Congress that grants open-ended rulemaking powers to the executive branch, basically abdicating its authority. They never have to come back to Congress for approval in any way, shape, or form. And then these are binding on individuals and businesses, both civilly and criminally. And then they've set up these so-called independent agencies, and there are pros and cons to this. But things like the Federal Communications Commission or the Securities and Exchange Commission, not the totality of what we think of as the alphabet soup of agencies, but a significant portion of them that are traditionally structured as bipartisan commissions where the president's party gets one more and gets the chairman of the commission. And then they are engaged in what the Supreme Court justified in a case called Humphrey's Executor, also from the New Deal era, as having both quasi-legislative and quasi-judicial authorities. And in Humphrey's Executor, they said, okay, well, the president can't actually fire these people. So the independent agencies, while they have to be nominated by a president and confirmed by the Senate, effectively are, through simple majorities in the commissions, able to write new rules that are effectively like laws binding on individuals and businesses. And then the president can't fire the folks if he doesn't like them. They don't have to go back to Congress. Congress can, of course, go through the process of overruling this, including through various processes that they've adopted through the Congressional Review Act and things like this. But in general, it's hard for Congress to act, and so there's an enormous amount of authority. And then the third sort of piece of this is the judging without the judiciary, and that's where we get these sort of doctrines where the Supreme Court has we both think gotten it kind of wrong and moved away from the statute, the Administrative Procedure Act that Congress set up at the end of World War II to sort of rein in some of this New Deal apparatus. And that's what I call judging without the judiciary, where the administrative agencies are often getting deference on the actual interpretation of the law. And I'll pass that back to you, Richard, to talk about it.
Okay, look, let me just start with a couple of points. The first one is very important, I think, to stress the real difference in approaches between the pre-1937 and the post-1937 situation. One of the ways in which this has been attacked in scholarship, which has actually reached a much more crescendo since our books were published, is the effort to show that everything that we do today was done in 1790 with these earlier statutes. And if you actually look at them closely, they don't do anything of the particular sort. So to give you but one illustration, people have claimed, well, it's okay to have a line item veto because the president can decide to spend or not spend any money that's put into the budget, notwithstanding the use of the word shall, which is a kind of negation. And they cite one of the earlier statutes having to do with pensions. And it says, well, that he could spend any amount. What they really said is you could spend up to a certain amount, but you must spend the amount in order to defray the expenses. It was never a situation that you could simply decide to put the money aside. And if we start to have that kind of a situation with the president, this is going to again run into the Jim part of the problem, that is the unelected part, where the president does this. The guidances are exactly the same thing. The executive orders are the same thing. The thought that you would be able to change major laws, for example, dealing with sexual arrangements and discrimination by an executive order when Congress has refused to do this for years, is a sign that there's serious trouble. The other problem that I think I'm going to talk about is how do you want to conceive of an administrative agency relative to the larger system? Jim was surely correct when he noted that in 1946, there was a very pronounced reaction to the excessive use of administrative agencies in the Roosevelt administration, which stopped more or less during the war because of everything else, and now is going to revive. People forget that both in 1938 and in 1946, the Republicans scored tremendous victories in the Senate and the House. And in 46, they used that to pass the Administrative Procedure Act. And the basic scheme of the Administrative Procedure Act was actually a pretty good one. We have these agencies now. We're not going to get rid of them. And the basic system said, look, on matters of law, these are questions to be decided de novo by the courts. By the time you got to Chevron, without citing the relevant provision, Section 706 of the Administrative Procedure Act, Justice Stevens, misreading all the pre-1937 precedents, said, well, there's always discretion in an agency to do more or less what it's want, and we're just following old practice. He wasn't. The older practice was if there was a consistent line of cases dealing, for example, with civil service promotion, you would never allow any administrative agency to make an ad hoc exception for one of its friends. But that then, by the time we get to the new agency, says if the agency decides to change a practice without explanation, that's perfectly okay. So in the first situation, Congress, of course, of dealing in custom is very powerful. Under the Chevron regime, it doesn't matter at all. And then on questions of fact, there's a division. Evidentiary facts are generally routinely decided by trier of facts without reviews, and ultimate facts are given some kind of increase. What happens is you get it slightly wrong there because whether they differ on law, there's a doctrine called the hard look doctrine relating to a case called State Farm, in which it turns out when you look very closely at an agency, you could really stop what it wants to do. Now, this doctrine is a little bit mischievous because essentially it makes the courts too powerful relative to the administrative agencies rather than powerful enough. You get things, but there's a mystery here which could be solved. The hard look is given when the administrative agency approves of some kind of a project. But if it turns out it wants to deny approval to a particular kind of project, then in effect, a rational basis deference is going to be used. So you get these fundamental asymmetry. There's also another difficulty, and I'll just mention this last one, is about when and how do you interact. Take environmental harms. This is an extremely complicated issue. Some acts that you take today will cause immediate damages. Some of them will only cause, probabilistically only, harms in the future. Now, what ought you to do? The correct system is, with respect to the immediate kinds of wrongs, you really ought to have rather decisive action. I've been involved in litigations against the Obama Presidential Center. They want to cut down 1,000 trees, and everybody says no big deal. They want to rep out a bunch of roads, no big deal. On the other hand, you look at the Biden administration, they want to shut down pipelines or have them re-examined because there's a 1 in a million chance that 10 years down the road something will go wrong with them, and all sorts of intermediate opportunities you have to improve the system or correct the kind of error. So on the remedial side, what we tend to do is to give passes to our friends, and with respect to those industries that we don't like, we give a very tough stubborn. Why are we doing this to the pipelines? Not because they're inherently dangerous, not because they are going to cause global warming, but because this is an indirect attack on fossil fuels. And so what you now see is the administrative agencies being used by the government people to achieve collateral ends which they could never get past directly. So the landscape is extremely complicated. Sometimes you get too much oversight by the court, sometimes you get too little, but they don't have any real strong mastery of the way in which these remedial structures are going to be put into place. And so I think, in effect, that this leads to a lot of increase. And then again, going back to Jim, the question is, if you see these kinds of errors, is there any kind of political way through popular election that you can actually reverse the flow that seems to be taking the courts with these rather dubious moves?
Yeah, and I think, there's the rub of it. I mean, the hardest part by far of my book to write was chapter 14, where I sort of was trying to say, how do we fix this? And the reason for that is that the political actors don't have huge incentives to fix some of this when it comes to Congress. I mean, this is really an inversion to where we were in the early part of the Republic, right? I mean, the early part of the Republic, when Joseph Story wrote about this in the 1840s, he's like, oh, well, we know that the Congress is supreme and they're going to guard that power. And about, not that long thereafter, they started moving the other direction. Then, of course, 90 years later, moved aggressively in the other direction. And if you just look at it from sort of a public choice theory perspective, what are the political incentives for the political actors in Congress, making a bunch of noise and saying we're trying to do something to fix this problem is what they want to be able to sell to their constituents. Trying to sort of micromanage, 61,000 pages in the Federal Register in year one of the Trump administration, 95,000 pages. I mean, it's beyond the competence of any of these individuals. And there are some very talented individuals in the Congress, but it's beyond the competence to try to take on that enormous task, which is why we get these delegations in the first place. So part of the problem, though, I do think, and just to reemphasize what Richard was talking about with the Administrative Procedure Act, is we sort of get it exactly backwards, both from what the Administrative Procedure Act says, which is that it should be an arbitrary and capricious review when it comes to the actual substance of the administrative rulemaking. But then the language, it doesn't say we should give deference to the administrative agencies, which is the Chevron v. Natural Resources Defense Council viewpoint. So it both inverts, and Richard sketches through some of this history in some detail in his book, the long-standing notion, sort of, we review carefully the words because that's what judges are capable of doing. I mean, there's this sort of soliloquy in back and forth in the Supreme Court oral argument of one of these recent cases between, I think it was Breyer and Gorsuch, and Breyer was saying, well, are we really going to be capable of saying how many nanograms of this or that are there? Do we want to be making those judgment calls? And Justice Gorsuch is like, well, what if we're just trying to interpret the meaning of the word relevant, which is something that courts do all the time, and it's what judges are required to do. And the real balance ought to shift in exactly the opposite way, such that when they're interpreting words, the courts should be. There's no reason at all to give deference to the administrative agency, in my view, when I'm talking about the interpretation of Congress's words in the statute. And conversely, we don't want judges trying to play mini social scientists and second guess these. But we've got them sort of inverted with Chevron and State Farm. And as I talk about in my book, just giving a little flavor to this. I mean, the sort of current personalities, our current Attorney General, Merrick Garland, argued State Farm and wrote the seminal article in Harvard Law Review piece that sketched out this sort of hard look review that gives the courts this sort of authority, particularly blocking sort of deregulatory moves by the administrative agencies. And of course, the person who took the seat that he was originally nominated for by Barack Obama, the Scalia seat on the court, Neil Gorsuch, his mom was one of the named parties in the original Chevron case. It was originally Gorsuch v. National Resources Defense Council. She was the EPA administrator under President Reagan at issue of those cases. So these personalities in the early 80s still with us today. These doctrines, I think, important. I do think the court is going to rethink some of these doctrines. I think the court in general is only going to to take the outer bound cases. And I think that's what the court is not. The court's not going to do a lot more than that in constitutional law. But I think at the outer bound cases, they are going to continue to rethink how Chevron works, rethink non-delegation. They've recently rethought the degree, or at least stood firm on the degree to which the presidential administration can and cannot be taken out of the firing business. And this was the case from the CFPB, the creature of Dodd-Frank, Elizabeth Warren's brainchild, where, and I talk about this in opening to chapter 2 of my book. We had two different people jostling for control of this agency, one appointed by the president and one appointed by the outgoing director, the Obama director, after Trump came in. And ultimately, the courts have said in these sorts of cases now, Richard Cordray, of course, our friend, the former Attorney General of Ohio. And so, these sorts of cases, I do think the court's going to do that. I do think the court could go further. I don't think it will, but I think it could go further. I mean, Randy Barnett talks a lot about a presumption of liberty principle in constitutional law generally. And I sort of throw this out there in my chapter on this when it comes to statutory interpretation, because there will be clear cases of ambiguity, right? We can debate about whether Chevron's ambiguous or not. This talking about, what's the stationary source? Are we talking about the entire plant or a single smokestack in terms of the regulatory authority granted by Congress? I'm not sure it's that easy to say that what we talk about in Brand X and some of these later telecom cases, I don't think there's any ambiguity in the statute, but, the courts have read ambiguity broadly to give deference to these administrative agencies. And partly what the court may want to do is just say, we mean it. When we say ambiguous, we really mean it, which is sort of what they did on the Auer doctrine, which is the Seminole Rock Auer line of cases, which is a separate line of cases on how much deference you give administrative agencies in interpreting their own rules. But my suggestion basically is, if there's ambiguity, why defer to the administrative agency? Why not defer to a liberty principle and just say you cannot assert government authority over an individual, including a business, and assert the use of government force implicitly over the individual if Congress isn't clear. And if you want more authority, go back to Congress. I mean, this is what I wish the court would do. I don't think they, in fact, will do that. I do think they will rein in some of the outer bounds there. And then the question is, could Congress do something too? And there have been a lot of sort of hypotheses and bills introduced over the years, the REINS Act, sunset provisions, all these sorts of things. And the way some of these could work, we see this in international trade law, for instance. Congress doesn't willy-nilly give up the ability to set tariff rates, which is a congressional power set under the Constitution, to the executive branch. And instead, what they'd give is fast-track trade negotiating authority to the president. And this makes some sense when you're engaged in bilateral, multilateral negotiations over hosts of points with foreign governments. You want to be able to hash this out and negotiate back and forth. But the president doesn't get what the president negotiates there. The president has to come back to Congress for an up and down vote. And so there may be mechanisms to do this where regulations expire without a congressional authorization, or they never are in effect, at least criminally, without a congressional authorization, or what have you. The problem there is, I think, the political incentives for the actors in Congress aren't that great. And that's particularly true of our friends on the more progressive side of the aisle, because it makes it harder to get big changes in the law and get big new rulemaking. But it's not as if the Republicans have aggressively pushed it. They've been introduced, but in part that may be due to some of the sort of implicit rules in the Senate that aren't in the Constitution, like the filibuster. And so, I always say when the Democrats are playing with this, be careful what you wish for, because we might be able to rein this in. Of course, they could flip it back if they get a majority on the other side. But there may be some of our sort of structural constitutional reforms that we've argued are good ideas that might be more achievable. But there's no chance of getting 60 votes in the Senate.
I want to go back to one point on the non-delegation doctrine to sort of indicate what counts as an outlier case, which is the topic that Jim started to raise. The case that seems to have generated the most angst recently is a case called Gundy, having to do with the question of whether or not sexual offenders have to register when they move to a new jurisdiction. And there was a debate before Congress, and Congress decided that somebody who's in prison at the time when released could be easily required to do so. One of the reasons is administratively, you just give them the notice on release so that there's no question of having to track people down. There's going to be no question as to whether or not there's ignorance of the law, which might count as an excuse. But the Congress could not figure out at this particular time whether they wanted this rule to apply retroactively, not to punish people who didn't register before the passage of the act, but to make sure that people who were released before the passage of the act would be given notice and then would be required to register. And this is a very hard question. So what they did is they decided to delegate this issue to the Attorney General. And the thought was that maybe he would do a kind of a detailed study and try to take advantage of the comparative advantage that the executive branch has, which is sort of its real ability to do fact-finding in one way or another, which Congress cannot do. What the Attorney General just did is says, I think it ought to be retroactive, and signed it. There was then challenge on the ground that this was an illegal delegation. And there were two responses to it, and I think it's worth mentioning both. The first is you start looking at the way in which the briefs come in. This is a criminal case, and if you want to talk about a presumption of liberty, criminal cases are the ideal places in which to do it. So there were a flurry of amicus briefs. I think I was involved in one, but I can't even remember anymore, from both liberals and conservatives, all of whom said this is an utterly improper kind of delegation to the Attorney General of the United States. And to echo Jim's point, I think the simple response is, if you can't make up your mind, then don't pass anything. You can't kick it through to some guy to do something which is a quintessential legislative act. And I think that simple point, you're not trying to figure out, how many micrograms of a given pollutant are going to go into the air. There's a simple up-down decision, the sort that Congress always makes, that you should require them to make it. Justice Kagan writes what I think is a somewhat hysterical opinion on this point. The most famous line from which is, if this case were decided the other way, the administrative state as we know it would come to an end. And that line has been picked up by many scholars who are constantly writing about the fact that this is a full-throated affair. It's nothing of the sort. If I mentioned it to you, it's a kind of a dichotomous decision, easily made. There's nothing about Congress which can't do it, and there's an easy remedy. If you haven't made up your mind, don't pass it. And then, by the way, when you do pass it, given the difficulties, what are you going to do? You're going to probably have to say somebody's going to have to fill in the details to tell us exactly how you get notice to these various individuals, how much time they have in order to file and to comply, what the penalties are going to be, what administrative procedures and oversight you're going to have. Justice Gorsuch makes a much ridiculed distinction without which the law cannot function, which he says Congress basically draws the broad outline, and it turns out that the administrative agencies start to fill in the gap. And if you go back to 1787 and 1790, that's exactly the way in which they thought about the subject. And, it's not perfect, but it makes some sense. But you can't say retroactive application of the statute is just a detail. And so what you do here in this current literature, you get a political dimension, which is there's so many people who are such passionate defenders of the current order that they've taken the position that any modification of any particular rule in any particular way of any particular thing means that it's the entire end of the administrative state as we know it. This is just false. I mean, and in fact, as a reformer, this is the way in which I proceed. I don't proceed starting from first principles because I'm in a given place where I'd rather not be. What I do is I look for low-hanging fruit and try to figure out those changes that I could make in the short run that will make a material difference in the way in which the system operates, and then go on to the next one. So I'll just mention one other, and I think Jim probably agrees with this, and I'll toss it back to him, is we constantly hear about these administrative agencies, and they do rulemaking. They also do adjudication. And one of the things that you discover is it is utterly incompatible to have people making and enforcing rules. Separation of power really manages. If you look at some of the cases like Lucia and Oil State, what you do is you discover administrative procedures in adjudication, which are essentially Kafkaesque in the way in which they're done. You load the panels, you allow people to revise these decisions. There's no principle of neutrality whatsoever. And so my first modest reform on this is to say that even if we cannot figure out a sharp line between administrative, executive, and congressional power, we can separate the adjudication function out, and all adjudication has to be done outside of the administrative agencies, You can use Article 1 courts. That's fine as far as I'm concerned. But you can't do it this current way. I've never seen a really strong reasoned argument on the other way. And I'm just curious, Jim, do you think that this is a sensible way to go? Or do you think that we really ought to allow business as usual on this dimension?
Yeah, no, I think it's absolutely the right direction. I mean, and listen, as you say, I mean, Article 1 is a sort of legislative courts as opposed to Article 3, the sort of federal courts. And, there are ways to set up different types of adjudications, but in essence, I mean, and this is what Phil Hamburger wrote about in his book in a more strong form than we are. I mean, I don't think we go as far as he does, but in essence, we are concentrating the power to write the rules, the power to enforce the rules, and the power to interpret the rules all in the same place. And that's what you hammer home as just anathema to a rule of law principle here, and something that I think we really need to be thinking about how that works. And I do think that it's important to understand that the executive branch has a lot of authority beyond the scope of the rules, and that's why some of these doctrines, I mean, they sound esoteric, but it's why they matter. I mean, for all the flaws in the way it's utilized and interpreted by the courts, the Administrative Procedure Act, and this is something Sunstein and Vermeulen, I think, point out, and where I think that we may agree with them in part, is there is some coherence here to having things like notice and comment period, where you have to give parties notice, allow them to comment, go through a formal rulemaking procedure, and then have some mechanism for judicial review of the rule. What we see happening in a lot of other contexts, and this is sort of the second section of my book, what I call the enforcers, and this is something we may want to shift to, because this is really where Biden has gone so far. I mean, we haven't had enough time for formal rulemaking. We sort of announced directions through executive orders, but that can go a long way to changing behavior, and so we see that happening over and over again. And I go through in the book some of these guidance letter questions on the Title IX cases, and these are things like sexual harassment, sexual assault in the universities, and different gender identity questions, all of which are difficult questions. I mean, I don't want to suggest that there's a clear policy answer on all these that is dominant, but what's not happened is, not only has there been no new congressional law that's passed to govern all these sorts of questions, there hasn't in many cases even been a formal rulemaking done by the administrative agencies to wrestle with these questions, to put in cost-benefit analyses and put in analyses that courts can review. Instead, what you see is the firing off of a guidance letter from a fourth or fifth tier employee in the Department of Justice or the Department of Education, or jointly, saying, this is how we interpret the rules and the statutes. And that guidance letter becomes the directive that's implicitly followed by the private actors running the universities or running businesses or what have you. And so, this is what we're sort of seeing a lot of happening in these early flurry of executive orders. I mean, I got sort of the numbers here through early April. The Biden administration has done 48 executive orders. That's one third more than Trump, who had 36. Obama administration had 33. The Bush administration, George W. Bush administration, only had 9. So this has been an aggressive expansion. It's not, executive orders have existed since the Washington administration, and there's nothing implicitly wrong with them. It's the breadth and the scope of these that has gotten so much bigger, and then this sort of what I call regulation through an interim effect or through enforcement. And part of my work that I've done empirically is to look at all these deferred prosecution agreements that the Department of Justice has reached with large businesses, where they're getting changes in business behavior that they're insisting upon that they could never get were they actually to adjudicate a criminal trial on these questions and get a conviction. And they're doing so with all sorts of dubious end runs around various safe harbors in the law, precisely because the businesses can't afford to take the risk to actually take them to court. Yeah. And it gives an unbridled discretion to some degree to these prosecutors in the Justice Department that are acting as major meta regulators without any rulemaking apparatus and no review in the courts whatsoever on the merits.
But look, I mean, I'm going to said some of the things, do a contrast, not only with respect to the numbers, but it's very important on executive orders to make it with respect to what's done. So let me take about 2 pipeline orders, since you see the contrast. I was very much involved in the litigation over the Dakota Access Pipeline, which still continues today, 3 years after the thing has been in operation, with a large number of what I regard as quite frivolous objections to the continuation of a pipeline which is safer than any alternative mode of transport that we have. And what happened in December of 2016 is the Obama administration took a look at this stuff and says, we want to have you file an environmental impact statement, notwithstanding the fact there was an 800-page report out there, which had answered every one of the questions that the government had wanted to raise. And so what they did is they basically want to stop this particular project, even though it was 90% completed. Indeed, they were stopping 1,100 feet of it from being built because it was governed by a mineral act of one kind or another. And what happened is the Trump administration comes in. What they do is they simply remove that particular order. It's not that they say we hereby command that the pipeline be built, but they said we'll respect the Army Corps of Engineers on this one. There's still need for congressional approval. We're not going to try to short circuit that, go through it. And they did. When it came to the Keystone Pipeline, of course, it was a very different proposition. What you did is this thing had been administratively approved, and then what you wanted to do is to stop it. What's really extremely difficult about cases like this is they're very difficult questions of foreign relationships that are going to be involved, because what you're doing is you're taking after the Canadians, and you've managed to jerk them around so many times that with delays of one kind or another. There is also some really substantive stuff. The Biden administration has gone gaga over with respect to what it believes to be climate change. And again, I don't want to prejudge this issue, although I think they're profoundly wrong on much that they say, but that's for another day. But what happens is it's not the leakage from pipes that don't leak that are going to cause this kind of damage. So as I said before, it's an effort to sort of control the distribution of fossil fuels. Now, this also has foreign affairs situations elsewhere, because these pipelines often go to ports, which then transport this stuff in tankers overseas. If it turns out you have reliable sources of natural gas going to Europe, that reduces the leverage that the Soviets are going to have with respect to their supply, so that there's a world chain to be considered. And writing an executive order, which was so juvenile and simple-minded in what it said, simply short-circuited all of those kinds of situations. In fact, just to put it generally, Jim did not mention this here, but he did mention it in the introduction to his book. One of the striking features about COVID is at the state level, the amount of unilateralism that starts to take place by such learned individuals as Andrew Cuomo decreeing this, that, or the other thing, or Anthony Fauci. I have yet to see any real reasoned statements that have been put forward on such important questions as, do we really need to lock down? Or some lesser procedure targeted perhaps to older people going to be appropriate? Is there any treatment that you would give to people before they're half dead and in hospital? What about ivermectin and hydroxychloroquine? These are not recommended today, although in widespread use everywhere else. And all of this is done by administrative order. And, I think, in fact, we probably have compounded the number of unnecessary deaths by virtue of these kinds of measures, so that this crisis has become much larger. And what we do is we now assume that the definition of an emergency with respect to suspension of rules doesn't apply for a hurricane or a typhoon that will last 36 hours. It seems to apply for perpetual curriculum. These things which are going on now, we have basically been in a state of quasi-emergency for 13 months. And I think you could make a very powerful argument that precisely putting us in that position has prolonged the very thing that we're trying to deal with. But we don't see any reasoned arguments on this. So I think the problems that we have in normal times, the tendencies that we don't like, are exaggerated when we get to these times. I don't know, Jim, should we take some questions or something?
Yes, please type your questions in. We've got a couple in here, one of which is just sort of simple, like, why won't the courts do more? And then another is more a positive, prescriptive one. Are there indications that the Supreme Court majority may curtail administrative state deference? And I've already said I think that the answer to that one is yes, or prior decisions like Wickard v. Filburn, which is, of course, the very broad commerce power interpretation in the 1940s that was basically reaffirmed relatively recently in the medical in the marijuana growing context. My instinct would be, I don't see Wickard being re-examined anytime real soon, but we do have a lot of new justice on the court. Who knows? I do think some of these deference doctrines are going to get thrown into place. I do think the non-delegation doctrine in some form is going to come back into play. And again, I think it's going to be at the outer bound sorts of cases, like the Gundy case we talked about, where we might see those sorts of cases. But what is your thought on that, Court? And why won't the courts do more? That's a hard question to answer.
First of all, I think we have to figure out who this court is. And it's not, I think, a simple 6-3 conservative majority. There are going to be obvious exceptions, more on the conservative side than on the liberal side in terms of block behavior. But I see this as a 3-body court. I see it as 3 conservatives, Gorsuch, Alito, and Thomas, 3 centrist conservatives. And I would put Barrett and Kavanaugh and Roberts in that class. And then 3 liberals. There are gradations for all of them. Bob Breyer is considerably more conservative on many things than Sotomayor, and Kagan is somewhere in between, closer to Breyer than to her, and so forth. So I see that. The area which seems to be attracting the most attention are a couple of them. One of them seems to be labor law. There are recent cases asking whether or not unions have the right to march onto employers' premises in order to spread the word. It's a very complicated debate. It actually goes back to 1945 with a case called Republic Aviation, where management was not allowed to stop workers in the exercise of their joint rights of mutual assistance to meet to form unions or other kinds of associations on company property, so long as it does not disrupt work. So the absolute right to exclude was gone. Justice Alito in Janus is very anti-union in the way in which he does it. And recently the case has come up again as to whether or not the farm workers union has the run of the place in order to try to organize. There's a broad ground and a narrow ground on which you could decide it. The broad ground to decide cases like this is to say, look, the trespass laws give you a right to exclude. Necessity cases are an exception. Forming a union is not a social necessity, it's a private advantage. Sorry, you can't do it. At which point, labor law, as we now know it, would come to an end. And there are a fair number of people on the left who believe that's going to happen. My view is that the middle group of 3 will in fact decide for management in this particular case on the simple grounds that the union violated the norms by coming in too early, wrong time, on the work floor, blaring horns and all the rest of that stuff. So I don't think that's going to happen. What I think is going to happen in labor and in takings law and so forth is that the incremental judgments will move right rather than left. But I don't think there are going to be any major discontinuities.
Yeah, I think that's right. And, in terms of why, it's hard to say, but I think it's important to understand. I mean, all of these folks have been trained in the law, and they've been trained in the law with some of these things as sort of a background presumption. And we saw this, when we're talking about the power of Congress. I mean, we saw this in NFIB v. Sebelius, of course, the Obamacare decision, where the Chief Justice Roberts, perhaps switched his opinion. Folks are sort of speculated that may have happened from the conference committee to the final opinions, but sort of writing for himself. You saw this sort of fear of the courts being held out as stopping what the elected representatives wanted. So some of this sort of fear of the anti-majoritarianism of the Supreme Court, et cetera, that's been sort of a guidepost running through a lot of constitutional theory back to the early Alex Bickle in the Academy. I mean, these sorts of fears I think animate at least some of the justices, the chief being one of them. And I think there's certainly a judicial minimalism in the writings of Amy Coney Barrett as well. She may be conservative on something like abortion rights, et cetera, but I think there's going to be a definite judicial minimalism in her jurisprudence that we'll see, which I tend to agree with Richard, that there's going to be a sort of, she's probably going to be more in a middle block than a flank block in a lot of at least these sorts of cases. And I think that is just sort of an old school fear of the judges, notwithstanding that, of course, the original Constitution in its original conception would have, I think, sharply curtailed some of these congressional powers that we're talking about. I mean, I do think that this sort of doctrine of constitutional avoidance and fear to not be outrunning the democratically elected branches will limit the court to some of these more outer bound decisions. I mean, I
Yeah.
think that's just the reality we face.
I mean, look, there's a very deep intellectual tension if you go back to the founding period. And Justice Scalia's enigmatic behavior in many of these cases reveals this. We were colleagues at the University of Chicago, and we crossed swords more than once on this kind of question, most notably in this sort of debate, so-called, that we had at the Cato Institute in 1984. But Scalia believed in two principles that ultimately prove in some degree to be incompatible. He's an originalist, and he wants to basically give a fair reading of the text and its public meaning, subject to the kinds of exceptions that conventionally would be understood at the time. Police power, for example. And on the other hand, what he wants to do is to believe in a system of judicial restraint so that the courts don't do very much to upset the dominance of the legislative bodies. So his form of originalism is, to some extent, is an effort not to essentially curb the legislature, but essentially to chain in the judges of the Warren Court mentality, and thereby he's willing to chain it himself. And so when you start coming to takings cases, you could see what the problem is. Nor shall private property be taken for public use without just compensation. That's not narrow. It covers every conceivable kind of public property that you're wanting to talk about. And so does it mean that you just can't take the fee simple absolute possession of land? Or does it mean that you can't take the air rights either? And if you start looking at state laws, we're supposed to do in determining property interests, it turns out that air rights are state law. By the time you get to the Penn Central and similar cases, what happens is, oh, no, these are not takings. These are, quote, mere regulation. And so the entire zoning system and so forth now escapes serious constitutional scrutiny. Anybody who's a serious originalist cannot live with that particular result. Anybody who's a judicial minimalist is compelled to accept that particular result. And I think if you start looking at this current Supreme Court, Justice Roberts and Justice Barrett very clearly would be we don't want to get our heads in something which we can't get ourselves out of it. Kavanaugh, I think, is a little bit more questionable on that, but probably in the same way. But 3 + 2 = 5. And so that means that you're not going to get a fundamental revamping of takings law, which I think we desperately need under these circumstances, because it's like everything else, rent control. The first scheme that you approve of, the 1920 rent control statute, seems pretty good, only for 2 years, only because of a wartime necessity. And then you get the monstrosity of New York State passing its current rent control rules. And what you say is rent control is rent control is rent control. And you don't see the enormous differences between these various schemes. And I think that's what judicial restraint does. It blinds you to salient differences. It means that when you get whole-scale confiscation, you just turn a blind eye. And Justice Roberts, for example, he still thinks of Lochner against New York as a decision to vilify at every possible occasion. And you put it with Korematsu and so forth. I ask you the following question. Korematsu was a legislative decision. Does that make it good? And it turns out, suppose you said that Lochner was a legislative decision and they repealed the maximum hour law. Nobody's going to treat that as one of the evil things in the world. The reason we do not like Korematsu or Plessy is because they are substantive commands that we find rightly immoral. Doesn't matter who does it. The reason we didn't like Lochner was because of institutional preferences. To treat these two things as the same order is just to completely misunderstand the way the history does. Nobody would want to say that the repeal of a minimum wage law is like the reimposition of segregation or the reimposition of concentration camps for people of Japanese origin. And he just loses sight of that. Too much Harvard education, too much judicial restraint, not enough independent thinking.
Yeah, I think that's broadly true. I mean, I think it's important to see the political dynamics. In 1937, and they call this the switch in time that saved 9, but that may or may not be the right interpretation of what was happening. But what was happening, of course, at that time was Franklin Roosevelt threatening to pack the Supreme Court. And, we're not going to get into what's happening here on this, but I mean, Joe Biden, while he's not threatening to pack the Supreme Court, has set up this commission with this sort of hammer out there as well on the Supreme Court, holding it over their head. And that's probably something that I think the Chief Justice react to. Now, the question here is, we've got another audience question, which is a little bit of a field from the administrative state question. But why do we see then these anti-majoritarian decisions like same-sex marriage and what have you? I mean, of course, I think it's important to realize that those were different justices. I mean, Tony Kennedy and Ruth Bader Ginsburg were in that majority. But it is a sort of interesting question. I think it does relate back to the civil rights movement. It relates back to, I mean, when the court was making these sorts of shifts in Caroline products, and in a footnote in the decision, and anyone of us who's been to law school will study this. The discrete and insular minorities, protecting the discrete and insular minorities, is held out as a constitutional bar in a way that ordinary regulatory legislation is not, and this is undergirded in the constitutional theory. This is part of John Hart Ely's Democracy and Dissent and what have you. So I mean, I think that this sort of thinking is somewhat embedded in our modern constitutional law on it. But it's an interesting question, because when it comes to a big piece of economic legislation, like Obamacare, like the Affordable Care Act, you have folks like John Roberts being hesitant to act. Now, in fairness, John Roberts also dissented in gay marriage, in the gay marriage case as well. So,
yeah, I mean, look, Jim, one of the things that's so argument is, who is the discrete and insular minority? So take two cases and compare them. One is Jack Phillips, an isolated baker who says, I don't want to bake a wedding cake that deals with same-sex marriage. Here are 10 places around the corner that you could go to, and I'm happy to supply you with any prepaid goods. And this man is now denounced in the most savage terms possible, death threats and everything else. Do we give him a protection on the grounds that evangelical Christians at this particular point are, in fact, a discrete and insular minority? And no, what we do is, with the Colorado Commission, we say it's guys like you that are responsible for the Holocaust, right? As if the refusal to deal could kill anybody in a competitive market. They do that. Then you get same-sex marriage. Let us be very clear about it. This is one of the most powerful blocks in the United States, not because of the number of people who, in fact, want same-sex marriage, but because of all the affiliated groups that are willing to support them. They are a juggernaut. And indeed, I think it's fair to say, with respect to the civil rights movement in general, after 1964, starting in 1971, it has become something of a juggernaut. If one remembers Gilbert, the decision in which Justice Rehnquist rightly, I said that basically requiring different treatments for pregnancy is not going to be protected by the Civil Rights Act and so forth. He was basically denounced for passing and approving of Dred Scott. The thing was overridden by statute. When disparate impact became an issue in Ward's Cove, and there was a sensitivity question, it was overturned by congressional statute. This is the most powerful lobby in the United States today. But they still think of themselves publicly as though they're a discrete and insular minority. And so if you're going to try and do this, you need a strong opinion to protect Mr. Phillips. And what the court should simply say, Obergefell, is that, this is the dominant thing. We have no objections whatsoever to doing it, but there's a long history in the opposite way. You should do it by legislation to legitimate it, which was the position that Jeff Sutton took, more or less, in the Sixth Circuit. And by the way, it would have passed precisely because this block is so powerful. And so what's happened is that Section 4 principle simply bears no relationship today, because we get to categorize the people we want in the way in which we want to do so, so that minority groups today who are constantly on the defensive, mainly Orthodox Christian groups, are treated as having dominant white supremacist power, and the really powerful groups that control Congress and the levers of power are treated as though they're being abject and subservient. And I think that we really have to understand that the demographic situation in the United States today is not what it was in 1938 when Caroline Products was decided.
And of course, Caroline Products, I've always made the case that, as a student of public choice theory, the whole analysis kind of inverts it, right? I mean, I studied the tariff. I'm from an old textile family, and what wins are concentrated interests. That's why tariffs had to be broken by Cordell Hull and the Office of the Trade Negotiating Authority, et cetera. And of course, it's dispersed interests that are weaker than concentrated interests when you actually look at the political incentives. We're almost out of time. I do want to give each of us like a 30-second tops answer. What's the worst thing? We got a new final question. What's the worst thing that can happen with the expansion of the administrative state under Biden, and how likely is this, Richard?
Well, I think what it is you remove all limitations with respect to both regulation on the one hand and taxation on the other. And taxation, that's in the form of getting rid of the realization requirement, which has been an essential element of the system for a very long time, and the imposition of a wealth tax in the way in which Elizabeth Warren seems to want to do it. Biden at this point is not pushing on either of those things. He just wants heavier tax rates. Bad enough, but not that. And then the other thing I think is going to be essentially complete government domination over labor markets in the short run. And that's AB5, which could ruin California, will now be taken nationwide. Because when Biden says that he's a union man, he doesn't understand what it means. I don't think he understands anything these days. But it is pretty clear that anything that labor wants, labor will get. And we cannot tolerate that in either the public or the private sector if it turns out you do get that degree of monopolization. The United States will become there. And the third, I guess, if you wanted to say it, would be treating climate change as such an absolute that nobody starts to think about how serious the danger is or why. There's a lot of hysteria going around that. I can't think of two less qualified people to bring into the White House than Gina McCarthy and John Kerry. And there they sit in non-confirmable seats, dispensing power in a way that I think is most regrettable for the nation.
Well, those were three, and I don't know that I have much to add. I agree with you on the labor stuff. Of course, this isn't an administrative state question, but overriding all, majority of states' right to work laws is now thought of as part of the infrastructure bill and what have you. And of course, one thing I wrote about in the Wall Street Journal this winter was on this sort of taxation or really appropriations question where this sort of enforcement power outside the rulemaking authority is used to strong arm putative defendants to give money to favored causes, which was a big way to get money to favored nonprofits in the Obama administration. And it's implicitly embedded in one of these executive orders. And we want to keep watching it and see what happens there. I want to thank everyone for coming. We're just over time. Richard Epstein, our friend, visiting scholar at the Manhattan Institute, NYU Hoover as well. I want to encourage you all, if you're interested at all in this sort of stuff, we've got a lot more of it. It's not up to date on all the Biden administration stuff, but we've got a lot more of this in our books. The Dubious Morality of Administrative Law by Richard Epstein, and my book, The Unelected, How an Unaccountable Elite is Governing America. I'll ask our staff to put links to those where you can buy those books and read them for yourselves in the chat room. So thank you so much, Richard, and thanks to our audience for joining us today for this Manhattan Institute eventcast.
And thank you for having me.